The Dershow.
To me, there are only two moments that distinguish between guilt and innocence in this case. The two moments are an alleged meeting that occurred involving Donald Trump and Michael Cohen and Alan Weisenberg. And it is alleged that in that meeting, Cohen laid out the scheme, the plan to pay off Stormy Daniels and then to list the payoff as legal rather than as remuneration for hush money that was paid. So only three people could conceivably testify as to that crucial meeting. It's the only evidence. There is no corroboration otherwise of Cohen's surmise that Trump directed him to make the payments and then list the payments as legal expenses, which is crucial. Making the payments isn't a crime. It's listing them as legal expenses, as retainer, as not as reimbursement. That is the alleged misdemeanor that's expired by the statute of limitations. But without that, you have no case. So obviously Donald Trump doesn't have to testify, and nothing can be inferred from that. He's the defendant. Cohen testified, and he's a liar. And so the question arises, where's Waldo? Where is Alan Weisenberg? Where is he? Only the prosecution could reliably call him, because if the defense called him, he might very well plead the fifth, but the prosecution can give him immunity. And so an inference should rise that the prosecution didn't call him because they believe that if they did call him, it would hurt their case, that he would testify, no, that meeting never happened, or I was at the meeting and there was never any discussion of listing the payments as legal fees. That's not something that Trump would have anything to do with. So I think a strong inference arises that Weaselberg, the missing witness, I'm going to get his name right one of these days, the missing witness would have hurt the prosecution. I didn't hear very much about that from the defense, and therefore I didn't hear very much about that from the prosecution. And then there's going to be whether we hear from the judge. Is there going to be a missing witness instruction? Ladies and gentlemen of the jury, you can infer from the fact that the prosecution didn't call Weisenberg that his testimony would have hurt their case. You can infer that. You're entitled to reach that conclusion. Are we going to hear that from the judge? Did the judge somehow make a ruling that I'm not aware of, precluding the defense from making that argument? I can't imagine that. That would be such clear, obvious error. It's such an obvious point that should be made. The same thing is true of the other witness, Schiller, I think his name is, the bodyguard. He is the only other witness to an alleged phone call that occurred. Remember, it's that 82-second or 92-second phone call, which was focused primarily on the complaint that Cohen was making that a 14-year-old kid was harassing him and giving Schiller the number and the name of the guy to follow up with the Secret Service, and then maybe a couple of seconds was spent informing Trump that the payments were being taken care of. That's an absolutely crucial phone call. Not as crucial as the meeting, because even if that phone call occurred, it's no crime. Even if Trump knew that there was a payoff, that's no crime. Trump would have to know that the payoff was being listed in the corporate form as legal fees or retainer or something other than remuneration for money paid out as part of a non-disclosure agreement. So it's an important call, but it's not nearly as important as the meeting. But even as to that call, there's a missing witness. And when there's a missing witness, juries are entitled to infer. Were I making the closing argument, I would have had a blow up, a full body picture, a blow up of Alan Weisenberg, and I would have said to the jury, ladies and gentlemen of the jury, you see this picture in the witness box. Should have been a person in this witness box. There should have been a live witness. Why did the prosecution deny you the right to hear that witness? What is the prosecution hiding from you? What are they afraid of? Are they afraid that this witness would testify that Cohen was lying about that, the crucial meeting? That's an inference you should be entitled to draw. So I would have had a full-blown picture. The judge maybe would have kept it out, but that would be a good issue on appeal and a good issue in the court of public opinion. What's wrong with using demonstrative evidence? Photographs are used all the time. Blow-ups of photographs are used all the time. If you're entitled to make the argument, you're entitled to illustrate it by having a blow-up of the witness who isn't there. But it didn't happen. And so, again, there's always a risk of second-guessing lawyers because you don't know everything they know. There may have been a ruling that I'm not aware of. There may have been a reason for it. But based on what I know, I'm not thrilled with the closing arguments of either side.